Members of
Hang on, yeah, now we're on. I said, I'm not on.
Thank you, Mr. Chairman, members of the Commission. Mr. Rubin, my name is Mitchell Willoughby. I'm one of the attorneys representing SC, and I have a few questions for you here today. The first thing I want to do, Mr. Rubin, is I think there's actually a few things that we agree on, and I want to go through those points of agreement. One thing we agree on is that canceling construction of the plants was the right thing to do for customers and for SC, correct?
Yes, we disagree about the time frame when that should have been done, but we absolutely agree that it was the right thing to do.
And so you take absolutely no issue with the fact that the company canceled the project. You find that to be prudent. You just think they should have canceled it sooner than they did, correct?
Yes.
And the second thing I think we agree with is that a reasonable result in this case is one that shares the burden of the failed investment between the customers and the company and its shareholders. And I think you define that as the zone of reasonableness, correct?
Yes, and again, I think we disagree on what a fair sharing is, but I'm glad to hear that you agree that there needs to be a sharing.
And in fact, you've looked at all of the, I think you indicated you hadn't analyzed the plans, but you at least are aware of the plans that have been presenting. And I think you just had a conversation with Mr. Tyson about the experimental rate, and you acknowledged that you had not examined that experimental rate or analyzed it, correct?
Correct.
But to his question and to other questions, what you have concluded in your analysis is that of all these plans, the only one that you think fits into that zone of reasonableness is your plan, correct?
Yes.
And so you have essentially concluded that no other plan fits within that zone of reasonableness but for your plan.
Of the plans that have been presented, yes.
But you would indicate, so does that imply then that you would think that there might be another plan that would fit within the zone of reasonableness other than your plan? You just haven't seen it yet?
Yes, and just to give you an example, I referred in my opening to the fact that there's litigation in the courts, and I understand that one of the issues being raised is whether some or all of the funds that have been paid by consumers should be refunded. Now, I'm not taking a position on that. I'm not involved in those cases at all, but it's possible that a result that would have some of that $2.2 billion refunded to customers would also be within the zone of reasonableness. And it's possible that that could go too far and be outside the zone. I just don't know. That's why I'm limiting my comments to the plans that I've actually seen presented in this case.
So what you're saying is a court could actually get it wrong and make a decision that would be outside the the zone of reasonableness, correct?
Hypothetically, that's possible, yes.
And you understand that Plan A that's been advanced by Dominion would refund to customers or give them an immediate cash payment that would be equal to about 60% of that $2.2 billion that you indicate that customers have already paid. Wouldn't that be a good thing for the customers?
I can't answer that standing on its own. If that were the only thing in Dominion's plan, it would be an easy answer. But in essence, Dominion is suggesting that they write a check to customers today and then recover that amount almost 3 times over during the next 20 years. So taking that plan as a whole, I do not consider that to be reasonable. And I'm also trying to understand that plan in the context of a merger when certainly the expectation is there will be some savings created by the fact of the merger. And Dominion's plan does not create or does not contain an element to return those savings to customers unless that's the purpose of the upfront refund, in which case it has nothing to do with the nuclear project cost.
Well, let me go to, I don't agree with that point, Mr. Rubin, but let me go to a point that I think we do agree on. And I think in your testimony, you made it very clear that you're not appearing here today providing legal testimony, correct?
Correct.
And so you recognize that it's the Commission's responsibility to make a determination as to what law applies and how that law should be applied to the facts of this case, correct?
Subject to court review, yes.
Correct. And so you're not here giving legal opinions. You're here talking about public policy issues, correct?
Absolutely, yes.
And one of the public policy issues that you cited in your testimony was that you indicated by looking at this body of law that the Supreme Court of the United States has given us, that one of the pronouncements that the Supreme Court has stated is that rates cannot be set so low or so unjust as to be confiscatory, correct?
Yes.
And I think you cite that in your testimony on page 9, lines 14 through 16. Is that correct?
I think it's actually goes a little further than line 16, but that's the right portion of the testimony, yes. Correct.
But I extracted from that block quote that you had there, basically the first sentence, correct?
Yes, and then the rest of that quote starts to define what confiscatory means, and that's an important part of that principle.
And we'll talk about that as well in a moment. So let's talk about public policy for just a second. You would agree with me, would you not, that the laws of a state are a primary source of determining public policy?
Yes.
And you've reviewed in connection with this case, you recognize that these plants were initially approved by this commission under the Baseload Review Act, correct?
Yes.
And you acknowledged in your testimony, and I'm going to ask you to look at, do you have your Sir rebuttal testimony in front of you?
Yes.
If we'll pull up on the screen, page 8. Let me get you to turn to page 8. And so one of the public policy pronouncements from that law and one of the public policy principles that you use in forming your opinions is that the BLRA, as it existed before it was recently amended, defines prudence as decisions made and actions taken by the utility based on the information available at the time that the utility could have acted to avoid or minimize the cost, correct?
Yes.
And you would agree with me, wouldn't you, Mr. Rubin, that that is a fairly standard definition of prudence, is it not?
It's, I think, a little different than what I usually see, but it's close. Usually it's the old sort of reasonable person standard or reasonable utility in this case. So it's not necessarily what the utility did, but what a reasonable utility under the same circumstances would have done. So it's very close to that.
That's right. But it's a reasonableness standard based upon what information the utility had available to it at the time a decision or action was taken, and whether or not the utility, based upon that information, acted appropriately to avoid or minimize the cost, correct?
I'm sorry, I'm not remembering every word you just said. I'll try to restate it, and if I miss something, please tell me. The essential element, I think, is what the utility knew or should have known at the time it was making decisions. So as long as that word available means either the utility had the information or it should have had the information because it was reasonably known, then I agree with you.
But let's just stick to the words. You've quoted directly the words of the statute in your testimony, correct?
Yes, and I think I'm just explaining what the words information available at the time means to me.
Well, that's what it may mean to you, but ultimately this commission will be the one to determine what is important and how those words should be defined. Right?
Of course, and as we said, I am not here to provide legal advice to the commission. I've never practiced law in South Carolina, and I don't pretend to. So I'm just explaining as a matter of policy what those words mean to me. If the commission disagrees or the courts disagree as a matter of law, that's the law in South Carolina.
And I would say to you, Mr. Rubin, you and I both are lawyers, is that when you're trying to put words on as to what available might mean, that's the standard thing that lawyers and courts and commissions do in trying to construct statutes, correct?
Well, I think it's more complicated than that. Certainly lawyers do that, but I spend a lot of my time wearing the expert witness hat, and that's a lot of what we're called on to do also, is do words have a particular meaning in the trade or, in the business? This one I don't think is any kind of term of art in the business, but in order for me to render an opinion, I still have to have some understanding of what the words mean. And as I said, I'm giving you my opinion of what those words mean to me. That doesn't mean that's the correct legal interpretation of the statute.
And as you offer those observations, you do so not as from a legal perspective, correct?
Correct.
Now, let's talk about the zone of reasonableness in setting rates. If I could get you to direct your attention, Mr. Rubin, to page 7 of your direct testimony. And I think there, on that page, and maybe rolling over to the next page, you cite for the commission some historical examples of failed nuclear projects. Is that correct?
Yes, it is.
I want to look close at two of those. The first one is a project that was very near you, 3 Mile Island Nuclear Station, correct?
Yes.
And just to put that in context, 3 Mile Island sits out in the middle of, is it Susquehanna River? Did I pronounce that correctly?
Pretty close. You don't quite have the Pennsylvania accent, but we say Susquehanna, but close enough.
And literally that nuclear station is within eyesight of Harrisburg, Pennsylvania, is it not?
On a really clear day, you can see it. It's actually, I think, about 10 or 12 miles from Harrisburg, but or at least, yeah, because when after the accident occurred at 3 Mile Island, they had a 10-mile evacuation zone, and Harrisburg was just outside of the evacuation zone.
And Harrisburg is the state capital, correct?
Yes.
Was it where your offices were located when you were part of the Consumer Advocate's office?
Yes, though I didn't start that job until about, I guess about 4 years after the accident, but that's where I was based.
Because the accident occurred in 1979, that period of time?
That's correct.
And so, but in any event, it would have been of great concern to the city of Harrisburg and to all of the residents of the city, and of course to the General Assembly and all parts of state government when that accident occurred, correct?
Absolutely, yes.
And then the commission there had to, I think you described it, and I think it's been viewed this way, as the worst nuclear accident in U.S. history. Is that correct?
That's the way I've seen it described many times.
And it resulted in a huge loss of investment in the plant, as well as a huge cost in terms of purchase power that the utility had to purchase in order to make up for the lost capacity, correct?
Yes.
And I think you go on to say, and I want to pull up a quote that you have in your testimony here. When regulatory decisions had to be made, the result was a special rate-making provisions were put in place to permit the operating utilities to cover enough of their costs to avoid bankruptcy. Is that correct?
You read that correctly, yes.
And then ultimately, General Public Utilities was sold to First Energy Corp. As part of the financial distress that company was under, correct?
Well, I wouldn't characterize it as being part of the financial distress. If memory serves, that sale occurred, probably at least 15 years, maybe more, after the accident. So at that point, General Public Utilities had recovered financially. One of the big problems was the accident occurred at 3 Mile Island Unit 2. At that time, Unit 1 was out for a refueling outage, but there was nothing wrong with Unit 1. But the Nuclear Regulatory Commission did not allow them to restart Unit 1 for many years. So the company incurred a huge cost in replacing power for a unit that was operational. And in fact, I worked on the case involving the restart of Unit 1, so that had to have been 5 or 6 years after the accident. And then by the time First Energy came along, Unit 1 was back in operation, and things were as back to normal as they could be at General Public Utilities. So I do not consider that company to have been in distress at the time of the First Energy merger, but it certainly was the final step in the full recovery process for that company.
And that transition period was over a 15-year period of time.
I'm trying to remember exactly. The accident was 1979. I left state government in 1994, and I worked on the First Energy GPU merger case for private sector clients after I had left state government. So it had to have been at least 15 years afterwards. It might have been closer to 20.
And would it be true as well that those special rate-making provisions were in place for that entire 15-year period of time?
No. Well, I shouldn't say that. The purchase power replacement really stopped to be an issue once Unit 1 restarted. And I just don't recall offhand how long the amortization was for the Unit 2 costs. I think that it had either ended or was about to end at the time of the First Energy transaction.
But it extended for some significant period of time.
Yes.
So now let's look at the next example that you called to our attention, Long Island Lighting Company. And I would note in Long Island Lighting Company, it canceled a nuclear project after an approximate $6 billion investment, as you report here in your testimony, correct?
That's correct.
And from Long Island, you observe that the investment in the plant was recovered in part by increasing customer rates and ultimately selling the electric utility to a public authority, correct?
Yes.
And I'm quoting, I have on the screen here, Mr. Rubin, your final sentence there, electric customers' rates increased significantly to bear some of the burden of the plant's cancellation, correct?
That's correct.
And I think you also indicated that at a period of time when this cancellation took place, the customers of Long Island unfortunately experienced the highest rates in the country at that time, correct?
That's my recollection, yes.
Let me hand to you, Mr. Chairman, I would like to have marked as the next hearing exhibit for identification a one-page document.
Okay, we'll mark it as exhibit number 82.
The exhibit number, Ms. Wheat, was 82. What I've handed you, Mr. Rubin, is a one-page press release issued by SC earlier this year, January the 11th of 2018, that reports the amount of property taxes paid to various entities in South Carolina during for that period of time. Are you aware that as a investor-owned utility that SC&G would pay property taxes?
I would expect it to, but I don't know the details under South Carolina law.
But it doesn't come as a surprise to you that they in fact pay a significant amount of property taxes to local government entities, does it?
That does not surprise me, no.
And you see here that the total amount of money paid in early 2018 for 2017 was nearly $210 million. Do you see that?
I see that number in the press release. I have no way to verify that.
And you can look here and you can see that some of the counties receive significant amounts of monies. Well, all of the ones reported here, significant amounts of monies, but you can see that Charleston County, for example, receives nearly $21 million. Aiken County, over $10 million. Lexington County, over $41 million. Richland County, $40 million. And the other counties there receive those amounts. Do you know, as a result of the Long Island lighting company, are you aware that, in fact, as part of the workout in that particular arrangement, that local property taxes had to be abated for a period of time?
Ooh, you're testing my memory here, Mr. Willoughby. I worked on, well, for a few years on some of the transactions that came as a result of that, including the ultimate sale of the company or of the electric operations to a public authority, and the sale of their natural gas operations to a separate private company. I believe there was, I know the local governments were very active in that. There were primarily 2 counties that were affected by that. I just don't remember the details, but I know there was a lot of concern by those counties of what the impact would be on their budgets as well.
And don't you have a recollection that, in fact, there was a diminution in the amount of money that they received from the public utility as a result of the financial circumstances that Long Island Lighting found itself in?
I don't have a specific recollection of that. I know there was, or I shouldn't say I know, I think there was litigation about the valuation of the plant after it was abandoned, and that would have affected property tax payments. But this was, this would have been in the late 1990s, mid to late 90s. Actually, one of a consumer group on Long Island was, I think, the first or second client I had after I left state government. So that would have been 1994, and the cases went on for a few years. So my memory is just not quite that good. Well, but I know there were a whole host of issues and a lot of activity by the county governments and concern about what this would mean for their assessments on the utility.
Would it be fair to say that as a result of that cancellation, that the burden was felt and shared by customers, by the utility and its investors, and local government entities that counted upon property tax revenue?
Yes, and I think I would add state government to that, because there, I believe once it became a public authority, there was a loss of some state income tax revenues as well. So there was plenty of pain, and it was shared by many entities.
And, all of that is, of course, unfortunate, and no one wants to be in that position. But when you're in that position, the best thing we can do is try to find the reasonable path forward, correct?
Yes, and when I say reasonable, I mean coming up with some way to fairly share that pain across all of the entities involved: customers, state and local government, utility investors. In this case, also the federal government because of the tax deductions involved, and then also the contractor on the project itself.
And so let's take a quick look. I want to direct your attention to page 9, and I just have a few more questions, Mr. Rubin, and I'll be through. You've got a block quote there, so let's go, Laura Lee, to page 9. And I think this is the quote that you and I discussed a little earlier. The first sentence out of your quote is: the guiding principle has been that the Constitution protects utilities from being limited to a charge for their property serving the public, which is so unjust as to be confiscatory. Did I read that correctly?
Yes, you do.
And while that's, as the old saying goes, that's easy to say, it's hard to get right in application. Would you agree with that, Mr. Rubin?
The devil is always in the details. Yes, sir.
And let's turn to your next page, which would be page 10. And you have a block quote there from the Duquesne case. And the last sentence, would you read that last sentence from your block quote? It's on the board here as well.
Sure. It says the Constitution, within broad limits, leaves the states free to decide what rate-setting methodology best meets their needs in balancing the interests of the utility and the public.
And there were words in there that says within broad limits. Is that correct?
Yes.
And would you agree with me that among those limits would be the limitations that have been set up in the Hope and Bluefield decisions that were previously issued in the 1920s and the 1940s by the U.S. Supreme Court? Do you agree with me on that?
That's part of it, yes. There are, several other decisions that all help to define what those broad limits are, but Hope and Bluefield are two of them.
And I've always found this to be very interesting. After you get to the U.S. Supreme Court, there's no other authority to which to appeal to, correct?
That is correct.
That is the end of the line, correct?
Unless you can change, ultimately, unless you can change the Constitution, yes.
Right. And so they've made those pronouncements, and that has been the public policy for rate making in this nation for certainly since those pronouncements. And all they were doing was basically enunciating principles that had been long used in utility regulation, correct?
Well, I'd say enunciating and helping to define them and put some meat on the bones, because they're, as I'm sure you know, every few years we seem to have another utility case or two make its way to the Supreme Court, and you get some further definition about where those limits are and how far you can or cannot go. But it all goes back to some of those fundamental principles about confiscation without due process of law and so on.
Certainly, and you would agree with me, would you not, that key principles in Hope and Bluefield is that a utility must be permitted to earn on property being used for the benefit of the public. Or strike that. Let me go to another point, Mr. Rubin. In your testimony, in your surrebuttal testimony, you criticized an event study that Dr. Hubbard had performed. Is that correct?
Yes.
And let me just ask this, because Dr. Hubbard will be here next Monday to testify. Would it be true, Mr. Rubin, that you are not a financial economist?
That is correct.
And would it be true that you yourself have not conducted an event study in this case, such as Dr. Hubbard did, correct?
I will say I did not do one. I have, as you can see, some questions about what Dr. Hubbard actually did, but I did not do that type of analysis. Yeah,
I recognize you had questions, and of course you've questioned a number of things here. You've questioned the experimental rate, you've questioned ORS's plans, you've questioned Plan A and Plan B by Dominion. But would it be fair to say, Mr. Rubin, that since you're not a financial economist, you have not done economic analysis in this case, correct?
That is correct.
Thank you very much. Those are all my questions.
Thank you. Mr. Reed.
No questions, Mr. Chairman.
Commissioners. Commissioner Elam.
Good morning, Mr. Rubin. Mr. Willoughby had you read a portion of your testimony from page 10, I believe.
of my direct testimony, yes.
Right. Further down that page, could you read the sentence that begins in the middle of line 19?
It says, in the Pennsylvania case reviewed by the court, the state legislature concluded that an appropriate result was to protect consumers from paying anything for plant investments that never provided service to the public.
Is your understanding of what the South Carolina General Assembly did is essentially at least heading in that direction?
Well, it's certainly it's heading more in that direction than the original Baseload Review Act was. I still don't think it's entirely there, but it's getting closer.
Okay. In your charts that you did in the summary, I believe you referred to that there's, I think you said $5.7 billion remaining for recovery.
In terms of the, if you're looking at the first chart, that $5.7 billion would be the total amount under, well, using round numbers under both the company and the Dominion plans. That would be the total amount paid by consumers.
Okay.
That includes the $2.2 billion that already has been paid.
Okay.
So it'd be roughly another $3.5 billion on top of that.
Is that in today's dollars or is there any adjustment?
That is, those numbers were taken from Mr. Collins' exhibits.
Okay.
I don't want to try to speak for him, so whatever units he used, those are the numbers I'm presenting.
Okay. You may have experienced something I've experienced, and you've taken cases to an appellate court and there's a written opinion, and later on people cite it for this or that, and you look at it and you say, well, that's really not what was going on in the case. Is there, accepting that the opinion speaks for itself, is there anything from that Duquesne case that you can tell us about the circumstances that we really can't glean from the opinion?
Well, there's always something going on that you don't quite understand, I guess, from reading a court's opinion. The Duquesne case, there were actually two utilities, I think, that had proposed investments in a number of nuclear power plants. The utilities, I think with other partners, ended up completing 3 units. The Duquesne case involved the cancellation of 4 that were not very far along. I don't even recall if ground had been broken for the plants. I think there was maybe $50 or $60 million mostly in planning costs and that type of thing. So certainly a different order of magnitude than what we're looking at here, or than what the Pennsylvania Commission had to deal with the 3 Mile Island accident and that type of thing. And there were several other plants planned for Pennsylvania that weren't even as far along as the ones in the Duquesne case. So we were one of the real hubs of nuclear activity, I guess, in the early 1970s. And a lot of that disappeared well before the 3 Mile Island accident. Some more of it disappeared after the accident. So just in context, there may not have been a lot of money involved in the Duquesne case. There were some really important principles for the country, ultimately, because the Supreme Court weighed in. But there were also some really important principles for Pennsylvania because we had all of this other nuclear activity happening at the same time. And this really helped to kind of define the ground rules that would govern not just $60 million of canceled investment, but ultimately was probably in excess of $10 billion of nuclear plants that were completed.
Okay. So the plants that were directly involved in that weren't as far along as we are or were with the building of the VC Summer Units 2 and 3.
Oh, not even close, no.
I've written myself a note, and I don't know whether you talked about this. Did you quantify or try to quantify shareholder benefits over 10 years from increased share value or dividends?
I did not, no. And I did talk about that a little bit. I think it was in my surrebuttal testimony, where I find that to be a very kind of unhelpful comparison. I mean, the stock market does what it does, and we can't always control that. I shouldn't say that. We can never control that. It seems to have a mind of its own, at least to someone like me. There were clearly benefits to shareholders over time through dividend payments and changes in the stock price, but the stock market is based on an underlying assumption that the investing public has the relevant and material information that they need to make a sound decision. There's some very serious allegations in this case that SCE&G and its parent company failed to disclose material information to investors. If that's accurate, then relying on what happened to a stock price is frankly irrelevant, at least in my opinion, because investors would have been deprived of the information they needed to make a rational decision. So I guess I would just ask you to be very cautious if you're tempted to look at what happened to investors because of the change in the stock price. If they were not being given material information at the time, then none of that means anything. Okay. Except it may result in a shareholder lawsuit, but in terms of benefit or detriment to investors, you can't rely on the stock market if that information wasn't being disclosed.
Okay. Going back to Duquesne, as a result of that decision of the Pennsylvania Commission, did Duquesne declare bankruptcy?
No.
You talked about that they had just a special rate rider.
No, Duquesne didn't even do that. The special rider was for the companies that own 3 Mile Island. Okay. But no, as a result of the Duquesne decision, there was a disallowance in the rate, but it was relatively minor, and Duquesne still operates today. They've never been in bankruptcy. They went on to complete other nuclear units, so there was, I don't believe any financial harm came to the company as a result of that decision.
Okay, talking about your recommendation about cutting off recovery of any NND costs as of December 31 this year with no refunds or credits to customers for NND payments made through December 31, 2018. If the Commission accepted that, what impact would it have on the company's ability to raise capital and provide reliable?
Well, that's a great question. From what I can tell, it would not affect the company's ability to raise capital when they needed to or to provide reliable service. From, I guess it was in Ms. Labson's testimony, she said that the company's debt covenants require them to have at least 30% common equity. My calculations, which are presented in the testimony, show that I think the worst case of a disallowance would reduce the company's common equity to about 35%. So still providing a reasonable margin above the minimum in their debt covenants. I don't pretend to know how Moody's and Standard & Poor's develop their bond ratings. It's possible they might downgrade the debt as a result. It's possible they wouldn't. Either way, that means there might be some change in the borrowing cost on new debt. It would not affect what the company pays on its existing debt, since there would not be a covenant violation. There are plenty of utilities. I mentioned in my testimony, almost every telecommunications utility in the country, except the two largest ones, have bond ratings that are below investment grade, and they're still able to raise capital and invest in their networks and provide reliable service to their customers. So I don't view a downgrade below investment grade, even if it happened, as being something that would prevent the company from raising capital or make it difficult for it to provide reliable service to its customers. So those are all factors I looked at because I think they're a relevant part of deciding what that zone of reasonableness is, and whether you're confiscating the investor's property. My conclusion was that you could stop the payments at the end of this year. Investors would take a write-off. The federal government would kick in a lot of money because of tax deductions. And the result would be you'd have a utility that would still be able to raise capital and serve its customers.
Okay, the comparison of, and I guess you're probably talking about AT&T and Verizon.
Yep.
Difference between that and SC&G is they're not regulated and subject to whatever the competitive market actually really truly is. They have a little more ability to change prices, don't they?
Well, yes and no. I do a fair amount of work in the telecommunications space, and there's still some regulation of AT&T and Verizon, and there's still significant parts that are not regulated. But no, specifically, I was talking about the smaller telecom companies, CenturyLink and Frontier, and there's a number that are smaller than that, that all have below investment grade bond ratings. They're all still heavily regulated. They don't have a big wireless presence. They're basically landline and data companies. And they're out there raising a lot of money without any problems. Every utility has some customer service issues. They're not immune to that, but I have not seen any indication, at least for most of them, that they're unable to raise capital in the market when they need it.
Okay, thank you. No further questions.
Thank you.
Thank you. Commissioners, any more? Commissioner Urban.
I wanted to ask you, looking prospectively, how we might, as a commission and a state, try to avoid this from ever happening again. And I want to talk to you briefly about several jurisdictions have moved to what they call performance-based regulation. Are you familiar with that term?
Yes, sir.
And so, is this something, we currently don't consider that in South Carolina as I understand it, but basically you try to set up performance incentives to strengthen utilities, to help them when we can, and also to protect ratepayers. What's your understanding, for example, of the two most commonly used forms of performance-based regulation, one being the APMs, and that's I understand that's award penalty mechanisms. Can you address that? And is there a way to build in some of those concepts into where we are at this point or not?
Boy, that's a question I didn't expect today. I am familiar with performance-based rate making. It can be very complicated, and at least in the experience I've had with it, it's something that you need to keep coming back to and adjusting. For example, you may, in an award penalty type of setup, you might set a particular benchmark for some measure of customer service, duration of outages, say, just to give one example. So you set a standard for that, and you say if you're better than the standard by a certain amount, then you get, say, a 10 basis point bump in your return on equity, and if you fall below by a certain amount, then your return on equity goes down and rates get adjusted. Well, what I've found in dealing with several of these plans is that there are a lot of interrelated pieces. For example, you might want to give a utility some kind of benefit if they save money on operating and maintenance expenses. But if the money they're saving is deferring maintenance so that safety is jeopardized or outages are taking longer to restore or and so on, then you need to continually come back and adjust those. So it's a different method of regulating. It's not necessarily easier, and frankly, to have it done properly, I think it's much more difficult, and it requires the utilities to do a lot of reporting, to come back to the commission frequently, and really to try to assess the pieces of the business you're not capturing in these mechanisms and whether there are unintended consequences. So it's not something I would go into lightly.
That's a fair answer. I just wanted to hear your thoughts on it. Do you have that in your state, or is your state commission doing that?
Our state commission is investigating the possibility of doing it. The statute was changed, I think, within the last year or so that gives them the authority. It's optional authority, so the commission has started an investigation to determine if they want to do it and what the parameters might look like.
And then the second method is what's called a multi-year rate plan. You familiar with that concept?
I'm very familiar with those, yes.
And what's your thought on that? Again, I'm sure it's complex, but
it's complex. In some ways, I think probably the best thing it does is minimize the frequency of rate cases, and probably the worst thing it does is minimize the frequency of rate cases, because the rate cases where you really get a holistic view of how the utility's operating, and you get a lot of public attention and input from customers and so on. So if it's a 3-year plan, that's probably not horrible. If it's a 5-year plan, that might be too long. I have experience in several states that use them. I think most are pretty happy with them. The state of Maine used to have, I think they were mostly 5-year plans, and they found that those were too long, and they basically stopped awarding plans that long. I think
it's fair to say it's hard to predict the future, isn't it?
Well, it is.
So many things are, so many moving parts.
Yes, and if you're trying to project out what a utility's capital investments will be 3 years from now, or how many customers it'll have, and that kind of thing, you're pretty much guaranteed of being wrong. It's just how wrong are you? So there's, a multi-year plan can have some benefits. Can provide the utility and customers with some level of certainty, but it's not necessarily more accurate than what you're doing now.
Thanks, sir.
Commissioner Whitfield.
Thank you, Mr. Chairman. Good morning, Mr. Rubin. Good to have you with us.
Thank you.
I didn't really have a question for you, but something you said in response to Commissioner Elam in your exchange with him just a minute ago kind of piqued my interest a little bit. And in the effort of comparing apples to apples and oranges to oranges, you were citing some of the telecom industry. You mentioned CenturyLink and Frontier, I think, having lower than investment grade and being able to attract capital. And then you went on to say, I think, that AT&T wasn't quite as heavily regulated as those two. I would agree with you. In South Carolina, certainly we have telecom utilities that are much smaller than the two you mentioned, Frontier and CenturyLink. But is it not fair to say that those telecom companies have other sources of revenue, such as the Connect America Fund through the Rural Utility Services, and a lot of these telecom carriers participate in both the state and federal universal service funds. So while we all know that landline companies have struggled, there are mechanisms out there for other sources of revenue, and I'm talking about obviously government sources with the CAF plan, and you've had two rollouts, CAF 1 and CAF 2. Could you maybe respond to that? Because I realize we're crossing sectors of utilities here, but a little bit hard. And I know you're trying to make an illustration with somebody attracting capital, but we are talking about two different types of utilities and two different streams, other streams of revenue. Is that correct?
Oh, you're absolutely right, Commissioner. And I didn't mean to imply that the telecom industry and the electric industry are the same, face the same challenges or have the same sources available to them. I was just trying to indicate that a utility having a bond rating that falls below investment grade does not cut off their access to capital. And there are lots of different sources of revenues that telecom utilities have that electric utilities don't, and vice versa. You don't have the equivalent of a wholesale power market in the telecommunications world. So, or not exactly the equivalent. I mean, there's some things
we don't have that here.
Well, you have the ability to transfer power to other utilities. It's not, you don't have PJM. You may want to be thankful for that, given some of what we're dealing with in PJM at the moment. But utilities don't exist as islands. They still have interconnections to other utilities and the ability to buy and sell power when they need to.
Certainly, so. We are vertically integrated in this state, and we do have a small amount of wholesale sales still, but we're certainly not part of a market like PJM or anything. Certainly, I would agree with you there.
So when I was the easiest example I could come up with from my experience of a utility that doesn't have an investment grade bond rating is in the telecommunications sector. I believe there are some electric utilities that are below investment grade. There are over 100 electric utilities. I don't have all their bond ratings memorized. But
I was going to ask you if you could cite some examples.
No, not off the top of my head, certainly. But, we've had electric utilities go into Chapter 11 bankruptcy and emerge from that. And we've had utilities in other sectors do that. So, and they still provide service to their customers, and they still raise capital when they need to. Their capital plans may change, as they're working through that process. I'm not suggesting Chapter 11 is on the table at all for this utility. It doesn't look like it is, at least not under the plans that are before you, including mine. But, if their bond rating were to fall below investment grade, they'll still be able to go to the bond market if they need to. They may not need to for an extended period of time. It just depends on what else happens in the business.
You say you're not suggesting Chapter 11 but some witnesses have put out there what they think their percentage chance of that. Would you be willing to say what in your expert opinion, what you think that percentage might be for the company?
I would not try to do that, no. But talking about the proposal that I've put forward, as I said, the company's equity ratio would fall to probably about 35%. That still gives it a good margin before it would violate any covenants on its debt. I haven't seen anything that would indicate the company would not be able to make payments on its debt or to pay its other bills when they come due. It doesn't, eliminating the surcharge that's in effect now. Obviously, it has some effect on the company's cash flow, but I don't think it's a significant effect in terms of its being able to pay its bills and make its debt payments when they come due. So I just haven't seen anything that would indicate a need for it to go to the bankruptcy courts for protection. If they do, it would be to try to get rid of some of the debt that they have and restructure its debt. That's a business decision the company would have to make if it can justify that. And again, from what I've seen, I don't think it could even justify it. It may not like having to pay back all of its debt, but if it's able to, it can't ask the bankruptcy courts to intervene. So at this point, I don't see anything here that says bankruptcy should even enter the equation. Now, if you want me to speculate, if a court were to say the company has to refund the entire $2 billion it's collected and do it immediately, well, that might create something that would make the company have to think seriously about restructuring its debt. But that's not before you. That's not something I've proposed. I don't think any of the other, I know none of the other plans have proposed anything like that. So I don't know. I just don't think that's an issue that's realistic based on what we know today.
Thank you, sir. That's all I have, Mr. Chairman.
Thank you. Mr. Elam, you said you had another question? Oh, I thought you did. Okay. All right, any other commissioners? No, thank you. Okay. Mr. Kaufman, any redirect?
Mr. Chairman, I have no redirect.
Thank you. Well, with that, Mr. Rubin, thank you for your testimony, and you're excused.
Thank you, Mr. Chairman.
Okay. Ms. Eaton, I know we're scheduled for this afternoon with Mr. Chris. You got, or is he here?
He's here.
Yes, let's do. Yep.
While Mr. Chris is coming forward to be sworn, I would move the introduction of Exhibit 82.
Okay, we will enter Exhibit number 82 into the record as Exhibit number 82.
This will take just a minute or two to set up.
There we go. Morning.
I have a few extra summaries.
Let's make sure that mic's on over there, Miss Eden, as well.
Absolutely.
There you go.
Is it on?
Got it.
I'm going to move it close.
Good.
Good afternoon, Steve.
Good afternoon.
Can you please state your name and address for the record?
My name is Steve W. Chris, CHRISS. My business address is 2001 Southeast 10th Street, Bentonville, Arkansas, 72716.
And for whom do you work and in what position?
I am Director of Energy and Strategy Analysis for Walmart Incorporated.
Have you testified before this commission in prior dockets?
Yes.
And did you cause to be prepared for docket 2017-370E pre-filed direct testimony dated September 24th, 2018, consisting of 15 pages?
Yes.
Do you have any additions, updates, or corrections to your pre-filed direct testimony?
No.
If I were to ask you the same questions contained in your pre-filed direct testimony today, would your answers be the same?
Yes.
I move that the commission accept Mr. Chris's pre-filed direct testimony into the record as if given orally from the stand.
Mr. Chris's pre-filed direct testimony will be entered into the record as though given orally from the stand. Mr. Chris, make sure you get close to that mic so they can hear you in Arkansas.
Is that better?
There you go.
And did you also cause to be prepared for docket 2017-370E, an exhibit to your pre-filed direct testimony consisting of 19 pages and identified as SWC1?
Yes.
Do you have any additions, updates, or corrections to the exhibit SWC1 to your pre-filed direct testimony?
No.
I further move that the commission accept Mr. Chris's exhibit SWC1 to his pre-filed direct testimony as the next hearing exhibit.
Mr. Chris's exhibit SWC1 will be entered as exhibit number 83.
Mr. Chris, have you prepared a summary of your pre-filed direct testimony?
I have.
Would you please read the summary of your pre-filed direct testimony to the commission and the parties in council?
Yes. Good morning, Commissioners. My name is Steve W. Chris. I am Director, Energy and Strategy Analysis for Walmart Incorporated. The purpose of my direct testimony was to address aspects of the application of Dominion Energy and SCANA's proposed merger agreement. My recommendations to the Commission are as follows. First, if the Commission approves the merger, the Commission should include, at a minimum, the level of bill credits and rate reductions proposed by the applicants. Second, Walmart does not oppose the applicant's proposed revenue allocation and rate design for the proposed upfront one-time bill credit. Lastly, if the Commission approves the merger, as a condition of transaction approval, the Commission should require that SCE&G, within 60 days of the close of the transaction A, convene a stakeholder process for the development of one or more new renewable energy offerings for each customer type, for example, residential, small commercial, and large commercial and industrial, to be proposed for Commission approval within 1 year of the close of the transaction, and B, work with interested large customers to structure the expansion of SCE&G's currently available interruptible service program and to file for approval of an updated program within 1 year of the close of the transaction.
Thank you. Mr. Chairman, Mr. Chris is available for cross-examination by the parties and by this commission. And I will say before he's examined that we very much appreciate the date certain.
Yes, ma'am. Thank you. Okay, Mr. Guile.
Thank you, Mr. Chairman. No questions. Thank you, Mr. Chris.
Cross, other parties. SCE&G.
Mr. Chairman, I don't believe either of the joint applicants have any questions.
Thank you. Commissioners. Commissioner Urban.
Thank you, Mr. Chairman. Welcome, South Carolina.
Thank you.
Of the 35 stores that you have that are getting electric service from SCE&G, do any of your stores currently have or use solar panels, solar energy?
I believe there are several that do. I don't know the exact number, though.
Is that you've asked for a stakeholders meeting, so I assume that's something you'd want to look into to see if that can be expanded? Is that true? Maybe not just limited to solar, but other renewable sources.
Yeah, I think that the basic premise is correct. In terms of what we've talked to SE&G about in the past has been something to target larger scale renewable resources, both to leverage the economies of scale that we can bring as load, and as well as other large C&I customers, as well as SE&G being the local utility and being able to procure larger resources on behalf of its customers.
Are you doing that in other states?
We are. So I mentioned in my testimony, we did work with Dominion Energy on their Schedule RG, which was approved last week.
Great.
Yep. Getting confirmation from Mr. Reed over there.
Great news.
We've worked with Georgia Power, we've worked with Alabama Power on programs for which we've already signed up, Ameren, Missouri. So there have been a bunch where we've gotten together, looked at sort of the relevant regulatory structures, the relevant resource availabilities, and tried to structure a program that both provides what we're looking for as a customer, as well as ensures that non-participants are not affected by the program being in place.
I commend you on your efforts. Thank you for being with us today.
Thank you.
Commissioner Howard.
Thank you, Mr. Chairman. Mr. Chris, good to have you with us.
Thank you.
You mentioned in your testimony that you would like to have the stakeholders come together and come up with some renewable energy resources. I'm reading, my question to you is, give me an example of what do you mean by that? I mean, what is the forum, how you can do that, and what would be the end results if you were happy about it?
So I think the forum would be either formal or informal meetings. Different states have different ways in which they do it, where interested parties can participate and talk through program structure, available resources, and get a picture for what's doable. As a large customer, we have these conversations one-on-one with utilities oftentimes, but one of the things I've found in working on program approval is that it's really important to include other stakeholders in the process at the time. So here in South Carolina, there'd be ORS, the industrial group, the developer parties, people who are going to have a vested interest in it, both in terms of participation as well as ensuring that other ratepayers aren't harmed by the program being in place. And so the process would really say, what sort of program are you looking to do? What's available? What are the barriers? How do we ensure that it's a good structure that's beneficial to everybody involved, not just the participants? And then go to filing at the commission. So that's the envisioning there.
Could you give me an example of what would come out of one of those meetings?
I would look at the Dominion RG that I mentioned earlier, that sort of program structure. A good example as well from next door in Georgia, in the Georgia Power 2016 IRP, they had proposed to build a fairly significant amount of new solar resource. We intervened, we filed testimony and said, hey, if you're going to do all this new solar resource, can we do a tranche for large C&I programming? Worked through the docket, negotiated a size of the tranche, so we ended up with a 200 megawatt tranche of resource. And that also came with a process around how that resource or the procurement of that resource would relate to other procurement they were doing. And then us, Google, and the Georgia staff worked with the utility to set up what the structure of the program would look like, and that's the value proposition. So what do the economics of the program look like? Because there's a cost part and there's a credit part, and figuring out what that's based on, how that functions, what the administrative costs look like, what termination provisions look like. A lot of standard contracting stuff, and then worked with staff to ensure that it was something that once it got to the commission would be acceptable to the commissioners and beneficial not just to the participants but to the public as a whole.
In Charleston, SC&G has an agreement with solar paneling on the Boeing plant. You familiar with that?
In general.
And my next question would be, do you have any of your stores now have solar panels on that roof? It's been discussed because of the square footage of your stores, basically. Has it been discussed, and what is the end result of your conversation, pros and cons?
So we do have several stores. Again, I don't recall the number offhand of sites under SCE&G that do have solar on them through the feed-in tariff program that was approved 4 or 5 years ago. I can't remember the date exactly. We know when we're looking at on-site solar, we do have a lot of roof space, but in terms of an energy consumption perspective, we can hit, I get the rule of thumb number is probably about 30% of our usage on site. So for a super center, we're looking at a system, somewhere between 250 kilowatts and 500 kilowatts. Neighborhood market's going to be smaller than that. And so in the end, that'll give us a good chunk of our usage, but it's still well less than half. And so as we talk to the utilities, we're really looking at how do we incorporate the larger scale resources in. We have a large footprint, but on our own, we might not be able to drive, a 100 megawatt solar farm or, a large wind resource. But when you put the program together, you create a structure for a lot of the large commercial customers. You get Targets, you get Best Buy, those folks, or you get some of the interested industrials in who to really drive that resource size, and then the utility can bring that resource into the program at a much lower cost than if just Walmart and SCE&G tried to go out and get a single resource to serve our 35 sites.
Thank you very much for your testimony. Appreciate it.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. Good to have you with us again, Mr. Chris.
Thank you.
Mr. Chris, a couple of years ago, you had a round of closures here, and it actually impacted my home community, was one of the areas hit. And I know you still have a lot, of course, in your testimony, a lot of facilities, a lot of stores here in our state. You even have a large distribution center, of course, in Chairman Randall's home county. But I noticed the second thing in your summary, you say Walmart does not oppose the applicant's proposed revenue allocation and rate design for the proposed upfront one-time bill credit. Two questions about that statement you make here. One, are you asking for a credit like the Department of Defense is instead of a check, if you will? And number two, what's the overall climate for Walmart now? How would this maybe have any impacts on Walmart corporately as it pertains to facilities in South Carolina?
So, to my knowledge, the result of this docket would not have any impact on our operations in the state. Store operations or any facility operations are, those decisions are made on a facility-by-facility basis through processes to which I am not a party. So I don't have a lot of visibility to what our corporate plan is. But certainly the outcome of this docket would not be a driver in that. To your first question, the portion of the allocation and rate design that we spoke to was more about how they would determine which classes get allocated what revenues, and then how what charge or credit structure would be created to return that to customers. You
don't care about the form of payment, is what you're saying?
No, just send it our way. We're good.
Okay. That's all I needed to hear. Thank you, Mr. Chairman.
Thank you. Commissioners, any other questions? Ms. Eaton, any redirect? All right. Well, Mr. Chris, we appreciate your appearance.
Thank you.
And you may be excused. Okay, we've gotten to all of our time, date, sensitive, certain witnesses today, so we'll start after lunch with SCE&G witnesses, and we'll be back at 1 o'clock. Thank you.